Do you believe, you heard Mr. Asaduddin Owaisi saying just now, Sanjay Hegde, that the Places of Worship Act is supreme. You cannot touch an existing structure. The only exception was made for Ayodhya. Today you allow a survey in Varanasi, it will open the floodgates. Does that argument hold, or has the situation qualitatively changed between 91 and 2022?
Well, the Act of 91 still remains on the statute book. And Mr. Owaisi refers to the Supreme Court judgment in the Ayodhya case, which said that this Act has been upheld and is part of secularism. Parliament took a conscious decision immediately in 1991. Parliament can yet take a decision maybe to abolish this Act altogether, but that has not so far happened. So any religious structure in place on August 15th, 1947 shall continue to have the same character. That is what Parliament has decided.
No, but the lower court, but Mr. Hegde, the lower court, by allowing the survey, has already effectively suggested that the Parliament, that the Act of 1991, in a sense, no longer clearly has gone beyond the 1991 Act, made an exception then.
See, the point is that it's a civil suit. The lower court should have possibly thrown out the civil suit at the first instance. It has not done so. Now it has allowed the suit to proceed, and it is in the process of allowing certain applications in order to bring some evidence on record. The court had appointed a commissioner to conduct a survey. There were doubts raised about the commissioner. Now the court today has added 2 more commissioners to aid the original commissioner. The interim order was challenged in the High Court. The High Court refused to interfere with the earlier interim order. That matter was not carried up further in appeal to the Supreme Court. If and when the matter reaches the Supreme Court in some form, we would have to see. Mr. Owaisi has asked a valid question. If at the end you can grant no relief, because every religious structure has to remain the same way as it was in 1947, then why do you proceed with the suit at all? That and other questions may have to be taken to a larger, a higher court.
You will have to take this to a higher court, but Tanveer Ahmed MIR, in the first instance, do you believe that the petitioners have won their first round, and therefore the Gyanvapi Mosque management is now in a predicament? Either they go and appeal right away to a higher court, or they will have to open the mosque, and that could lead to further repercussions.
Well, Rajdeep, that's absolutely correct. The order passed by the court concerned in Varanasi certainly is beyond the parameters of 1991 Act. And since the court has passed an order to the detriment of one party, it is now obligatory on the other party to take this matter up and bring it to the notice of the appellate authorities or the revising authorities in the High Court, or even straight away petition the matter under 136 to Honorable Supreme Court of India and bring it to the notice of the Supreme Court that what is going on is totally impermissible. This cannot be done at all. This is beyond the Act, beyond the legislature. It is also in violation of the preamble of the Constitution of India. At the end of the day, the religious places as they existed in 1947 is a part of Indian ethics and Indian ethos. Whether it is a temple or a mosque, it belongs to every Indian, irrespective of what community and the religious spiritualism that he believes in. Therefore, I believe that there are very strong political forces operating on the ground zero, intending to spread communal poison. And the 1991 Act perhaps was brought and indisputably brought by the government then in power to kill this poison. Unfortunately, what we are seeing over all these times is that there are now so many manifestations to keep the communal pot boiling. Therefore, it is an incumbent responsibility on every Indian to oppose all such moves.